I hope you had a nice stay and a nice interaction in Shillong. And I'm very thankful to Bodhi for giving me this opportunity, and to you all for your time. It's a very good idea to try and listen, It is a good idea. If you go and interact to any place, it'll be good to learn about something about that place. So I hope everyone has a copy of that paper. I tried to think of what I could share with you yesterday, and couldn't read the whole thing. But then anyway, a few of it is basically our issues here today is about two books. This is one book. The Indian Independence Act 1947. And this, by the way, impacts all of you. The Indian Independence Act 1947. So we trace our issues starting from the Indian Independence Act 1947. And then we come to this other book, which is called the Constitution of India. And so, we have not yet concluded our issues with this one, and we have to deal with this one. So, I don't have a copy, but later on you could... So, you may ask me, how come 1947, the Indian Independence Act 1947, and till now, these issues are, pending till today. So, I will tell you right away, this is a copy of the resolution. This is a copy of the resolution passed by the Meghalaya Assembly, 23rd March 2015. So, I've showed you the Indian Independence Act 1947. I've showed you the Constitution of India. I guess all of you know what's there, and I've quoted a number of articles there. And let's just go to the present. The present is this resolution passed by 60 legislatures. In Meghalaya, we have 60 MLAs. So 60 MLAs passed this resolution in March. What was the resolution about? You're all aware of NGT. You're all aware that NGT passed directives, orders, requiring all coal miners to comply with statutory laws, to comply with the laws of the land. Two of them, namely, principal acts, the Coal Mine Nationalization Act 1973 and the Mines, Mineral Development and Regulation Act 1957. These two. You may be wondering why I'm talking about Coal Mine Nationalization Act 1973 and the Mines and Minerals Development Regulation Act 1957. So here in Meghalaya, this resolution the Meghalaya Assembly passed in March 2015. So it says here, and whereas the government of Meghalaya had notified the Meghalaya Mines and Mineral Policy in 2012. So every state, they have to have a kind of a mining policy. So, government of Meghalaya, at that time, I was a member of one committee there. I was invited once, and after that, I was not informed anymore. So, they framed a policy. In that policy, they said, one of the paragraphs, they said, small traditional miners will not be disturbed. Then somewhere down below another proviso, they say all the statutes, the laws, rules, regulations will be complied with. All the central laws and regulations. So, at a committee where I was called and invited to express my views on that policy, the draft policy, it was a draft then. I told them, you can't do this because there is a conflict. There is a constitutional anomaly in the Constitution of India. Because we had here in Meghalaya, especially in Khasi Hills, 25 Khasi states, what they call them in the rest of the country as princely states. We were not those princely states. So 25 Khasi states, they signed the standstill arrangement. There was a standstill arrangement on 16 July 1947. Then they signed the instrument of accession on 15 December 1947. There was a conditional accession with some terms, some agreements. One of the few agreements there was our rights over minerals, land, water, forest, judiciary, revenue, excise, territorial boundaries, and last but most important, our rights relating to legislative issues, where it was said that the chiefs would have representation in the legislature. But till today, we don't have representation in the legislature. So it was written there also that where legislation where necessary shall be framed or legislated to suit or modify the conditions as prevailing here. Now what had happened is that agreement did not enter the Constitution of India. You don't find it here. You find the instrument of accession of Jammu and Kashmir under Article 370. So the chiefs have been demanding for the last 67 years, reminding the government of India that you have a treaty with us. And you have to mention the treaty here. So I'm known for shouting for this issue, but there have been people before me who have been doing the same thing. So we have met the central leaders, we have met the government of India. Now they kick the ball back to government of Meghalaya. Meghalaya kicked the ball back to district council, and so on and so forth. So anyways, while that is going on, there have been judicial interventions. For example, for the first time, the village chiefs, more than 400 of them. At the higher level, we have only about 54 chiefs in Khasi Hills, 54, 19 in Jaintia Hills. Under them, they have, in Khasi and Jaintia Hills, they have almost 3,600 village chiefs. So, the day before you arrive in Shillong, more than 400 chiefs had a peaceful march around the governor's house, the Raj Bhavan, demanding him to pass a bill. There was a bill sent by the district council which is relating to the powers, function, the role of the village chief. Basically a codification of the traditional institutions. So that is going on. And you can very well imagine the complexities, the complex situation where even the governor could not understand what this is all about, that bill was all about, that he had to send it to the Home Ministry in Delhi. It's a simple matter. In fact, I have passed a comment in 2-3 places. I said maybe this governor has become an extra constitutional body. You know, on the one hand they say you have a district council, they are elected members. Then you have the Meghalaya Legislative Assembly, which is also an elected body. And you know, they say House is supreme, even Parliament, you know. Now, theoretically, when the district council, by law, when the district council send a bill to the governor, it goes to the government, the state, and it's a matter of routine. The governor should actually just pass it or send it back with whatever views he has. Since May till today, the governor is confused. He has not passed the bill. In fact, he has sent it to Delhi, to the Home Ministry to define how I should live, how I should be governed, whether this is okay or not in the national interest. That is a reflection of our treaty. Because I had already told the district council also that you will find a lot of problems because our traditional laws may not be in consonance with the panchayat laws. At times I say thankfully for judicial intervention. So NGT came in, people complained to NGT about pollution, about this and that. And it went to a hearing. And during the hearing, I recollect the Advocate General of Meghalaya. He was trying to impress upon the justice, who was the chair of the NGT court, and told him, this is scheduled area, this is tribal people, we own the land, it's private land. He said, Dad, you go and explain somewhere else. My job here is to go according to the Coal Mine Nationalization Act and the MMDR Regulation Act 1957. Now, what did that act say? So everybody started reading their books. Coal Mine Nationalization Act 1973, Section 3. Section 3 was inserted in 1976, which acquired all the coal mines in India. So technically, as I think it happens all over India, the coal mines belong to the government of India. For the last 200 years, we have a record that way back in 1820 something, we were already shipping coal to Japan. Of course, through British came and took the thing. So, for 200 years, we were mining coal in our own land. Like I said, our clan land, private land, community land. We didn't think that the central laws would, finally catch up. So when the NGT came in, the NGT said, no, you cannot mine unless you go according to the regulation, the rules and regulation. That got everybody sitting up. The chiefs again wrote to the government and said, this is due to the lack of clarity in the Constitution of India relating to our treaties, our rights. So anyway, 6th schedule, we are under the 6th schedule. So under the 6th schedule of Meghalaya, I think, like I said, we have 10 district councils under the 6th schedule, 3 in Assam, 3 Mizoram, 3 Meghalaya, 1 in Tripura. So under the 6th schedule of Meghalaya, for Meghalaya there's a proviso, para 12. Para 12 says, if there's a conflict between state and district council law, state law will prevail. This was newly inserted when we attained our new state in 1972. To have, a semblance of connectivity, continuity. So the inserted para 12A, and 12A was supposed to be for, in case there's a conflict of state law and district council law, like for example today there's a big debate going on relating to building bylaws. District council says all the people must go according to our building bylaw. State government is saying, we have already made one building bylaw. According to that act, the Town Country Planning Act of the Government of Meghalaya, which they passed in 1973, there was a proviso there. Provided the district councils agree, this can be extended. So district councils never agreed, the state never consulted them, but notified ahead all this building bylaw. So today the district council has woken up and said, no, this is my territory. People will go according to my building bylaw. So they are having this discussion. I'm referring to this because we have para 12A. We have para 12AB. Para 12AB says the president may, not shall, the president may, by notification, exempt any act of parliament by notification to any autonomous area or region in Meghalaya. So under that proviso, this is the second time that Meghalaya government has had to pass a resolution under para 12AB to request the government of India, please remove this Coal Mine Nationalization Act and the MMDR Regulation 1957. So you can very well understand the issues here now, primarily being land, its resources, and our rights. So what did the government say here? That whereas the government of Meghalaya had notified the Meghalaya Mine and Mineral Policy 2012, which I had objected to, with a view to inter alia promoting safe, scientific, sustainable development of mineral resources in the state. And whereas, now's the interesting part. This is in 2011 actually I objected to it. Now in 2015 they say like this. And whereas while implementing the policy, it was discovered that the customary and traditional practices and rights were coming in conflict with the provisions of Mine and MMDR, no? Act 57 and the Coal Mines Act 1973. You see, so this resolution went to Delhi. Then Delhi said, "Arey, what happened if Andhra Pradesh? What happened if Jharkhand? What happened? They'll start." So anyway, Meghalaya government has replied and said, "No, this proviso in the 6th schedule is only for Meghalaya. When the other states have it, then they can claim it." But we from our side, from the chief side, from the Federation of Khasi states, from the Council of Chiefs, we are reiterating that this para 12AB is actually reflective of our treaty. And anyway, so government is still trying to address it on a case-to-case basis. I told you this is the second resolution. The first resolution was on the Forest Conservation Act. This is way back in the year 2000. They passed a similar one. In the year 2000, as we are in conflict with the Forest Conservation Act 1980. What does the MMDR say? The Mine and Mineral Development Regulation Act 1957 says, only those who have a lease can mine. So you all remember the Colgate scam, because there was no directive on how to issue a lease. So the Minister of Coal was giving it left and right. And that's how the coal scam took place. And the Supreme Court has said now, henceforth, you will issue a lease by auction. So recently they conducted an auction and Government of India got a lot of money. Now come to Meghalaya. So what does the Act say? The Act says you can only do it by lease. So we had a meeting with the government and asked them, where is your land to lease it? So I was jokingly telling the government that yes, you can lease. You can lease Raj Bhavan, you can lease Secretariat, you can lease Civil Hospital, where's your land? And furthermore, they amended this MMDR Act in 1957 in this session in Parliament and added, this proviso which was directed by the Supreme Court that it should do only by auction. So a lot of people here are yet to comprehend that if at all they have to go by this system, they, it's like whole of Nehu could be auctioned, neighboring Nehu could be auctioned in Delhi. So, this serious conflict is going on. And it's the same issue, I think, what's happening in Nagaland. I contacted some friends there and they also have passed the oil and gas regulation law that, the state is going to do it. So they're still in conflict with Government of India. Where Government of India is saying, on the other hand, as I mentioned in my paper somewhere there, the 7th schedule, coal again is a major item and is under the 7th schedule. Oil, gold, uranium. Government of Meghalaya has passed this resolution, which is an ample evidence of the issues that the Constitution of India is yet to recognize our rights. It is very unfortunate that we have, we have a lot of problems as a people. I was telling Professor Khaka yesterday that I recollect I made one statement way back, I think at least 10 years ago, when the Home Ministry, the Ministry of Home Affairs, in the Telegraph newspaper, brought a full-page advertisement, would have been very expensive, full page, announcing the achievements of the Home Ministry, the number of accords. They listed the number of accords. Assam Accord, Bodo Accord, this Accord, that Accord, Darjeeling Accord. So I remember the chiefs made a comment, and on their behalf I issued a press statement saying, does the Home Ministry address problems only through accords? Only through, because the accords have been arrived through violent measures. So advertising those achievements as accords was wrong. I feel it's wrong because, that means you are trying to tell us, telling the chiefs, that if you go democratically demand your rights for the last 67 years, nobody will listen to you. Just like today, our brothers in Garo Hills somehow have got an accord, an ANVC settlement, which I don't know how they'll fine-tune it. 26 September 2014, they signed a peace agreement with the government of India to fine-tune the 6th schedule. It's a very sad thing to tell you, but one of our chiefs, I happened to sit in the court because some people went to court, and then suddenly the judiciary passed an order saying under which law, under which rule are these headmen issuing the NOC? They issue certificate of residence, residential certificate, this certificate, that certificate. Under what, So after a lot of debate, the judge passed an order that they cannot do this. So one fine day, one of the village chiefs went to the press club to give one briefing about some incident that happened in his village. The press also unknowingly asked him, hey, what about the NOCs? Are you still issuing NOC? He said, yes, I'm still doing it according to my practice. Next day, the press headline was, village chief violates High Court order. And the fellow was called to court, contempt of court. He was sent to 20 days of imprisonment for that purpose. Here in Meghalaya, there is a big debate about our a resurgence and a debate about our rights, and we from the chiefs have been writing for a long time with the government of India. We have been petitioning the President of India. What was our problem? Our problem was in relating to addressing the instrument accession and the annex agreement was because of Article 363. There's an article in the Constitution of India, 363. Bar to interference by courts in disputes arising out of certain treaties and agreements. See, when they framed the Constitution, there were more than 500 agreements. Accession and then merger. So when you signed a merger, then you lost everything. So at that time, they also came to Meghalaya to get our chiefs to sign the merger. To which the chiefs just point blank refused because, again, they were not the landowners. They could not sign. Because we have almost 16 category of land. Re Bams Aim, Re Hurit, Re Raj, Re Seng, Lau Kantang, about more than around 16 categories of land. Individual land, private land, community land, clan land. A lot of it is clan land. So, they could not sign. So when they told Sardar Patel, in fact Sardar Patel came here to try and discuss this matter because he had got almost 500 Maharajas to all sign it. So when they explained to them that they cannot sign it because they are not the landowners, that's how they got stuck. So this proviso 363 was kept to stop any dispute arising, to go to the court. So this is another issue which is why we have not been able to go to the court, because the courts have already been barred by 363. We've had some opinion from the courts who've told us that you could go to the court and tell the court to tell the government of India to make effect this agreement. That is a possibility. But probably you can't go and reopen the whole thing. You could only tell the government of India to make effect what they have agreed to. What they have agreed to was is that we are supposed to have a legislative council of the chiefs. We have to have a legislative council. I remember in my discussions with Delhi, they said, why you want another council? You have TICI council, you have state assembly, why you want another one? My answer was very clear. The chiefs are not represented in the TICI council. The chiefs are not represented in the state assembly. Whereas they are the principal signatories of the treaty. One more thing I would like you to also understand. Our institutions here are partyless. Unlike the district council or the state assembly or the parliament, which comprises of people representing the parties. So we have a situation here which is partyless, which is which is not party based. So recently, the government of Meghalaya, like I told you just now, they signed an agreement with ENVC, our Garo friends there. The insurgent group ANVC signed an agreement with the government of India. Now I found that the cabinet of government of Meghalaya has proposed to the government of India to have few nominated chiefs from to have nominated members, one nominated member as a member of the TICI council, to which the chiefs have rejected the idea. Why did I remember the chief minister asking, why you are not accepting this? We said, it's not easy. How can we sit in a council of parties? We will have to vote. We will have to topple the, because here a lot of toppling takes place. So, our system of government is by consensus. In the normal parliamentary system of the country, you go by majority. They say, he won by how many votes? Or they say, he won by one vote. Vajpayee government lost by one vote. I don't know if you remember that. Right? So, we don't have such a thing. We don't have opposition or ruling. It is not easy because you will have many meetings. Supposing there's a subject, and if we are not, it will continue. That subject matter will continue even for 6 months. Continue to have the deliberation until it is decided. So, this is our, what I should say, the ground reality that we have here. We have institutions. Are they alive today? Yes, they are. How are they alive? You can see even the government of Meghalaya today, through its resolution, is confirming that the system is still alive. So, thankfully now, the district council in Meghalaya, you can write down one website, khadc.nic.in. If you click there, you will now find the acts, rules of not all the kingdoms. Unfortunately, we've had very poor quality of representation in the district council in the past. So they have not even realized that they had to codify this. So the codification of these 54 kingdoms is going on. Very interesting. It's a very interesting situation. You will find in these acts, there is an act called the appointment, the KHADC, Khasi Hills Autonomous District Council, appointment of chief, appointment and succession of Chief and Headman Act 1959. The KHADC, appointment and succession of Chiefs and Headman Act 1959. What does this act? So this act basically codifies how you when there's a vacancy, how you elect a chief. But that act also went to court so many times. So finally the district council had to make separate appointment and succession act for each kingdom. Because separate clans, separate chiefs, separate tradition. One more interesting proviso in all these appointment acts is that there is a proviso which says no chief no deputy chief shall take part in politics. In fact, I wrote a letter to the Chief Election Commissioner, and I told him in my letter, as a partyless man, assuming if I was a partyless man and I was, for more than 10 years, I went on a partyless plank. And then they said, what a useless fellow. He doesn't even belong to any party. That's the comment they had. They said, why do you listen to him? He doesn't even belong to any party. So I wrote to the election commissioner. I said, I want my chief and his council to tell me which political party will safeguard and protect my interests. I've forgotten his name, the Chief Election Commissioner. Then I said I would like to have an appointment, because on the one hand, the superintendence of elections in India is solely the jurisdiction of the Election Commission of India. So he called me back to say, who are you? I said, well, I represent the chiefs. Are you MP? No. Are you MLA? No. Who are you? I said, no, I just represent the chiefs. Who are these people who have barred you from contesting elections, or, are they government servants? I said, no, they're not government servants. No, because government servants have service rules. How can they think this is our domain? How could they make a law to bar you from this? So I explained to him. Finally, he said, okay, I will look into the matter. And then he wrote a letter to the state government. Then the Chief Election Commissioner of Meghalaya called me. We had a cup of tea. He said, where did you get the idea to go and write to the Election Commission to complain about this law? I said, well, on one hand they say it's a free and fair election. But this law bars my chief from participating in the Indian election in a free and fair manner. So he also didn't know what to do. Finally, the Chief Election Commissioner's office wrote to me saying, please take up the matter with the Ministry of Home Affairs, New Delhi. You see, so I should say this, it's a long journey, it's a long struggle. It's quite a challenge to try and explain the majority community of India about this different kind of institution existing here. And I think I was very happy to meet somebody from Arunachal yesterday, because I think they also have a similar, So I was trying to connect with some of the institutions, the governing institutions, I don't know if you have them. I did get in touch with some people from some village chiefs from Ukhrul. They also have, I don't know what is their system like, but I would really like to know some of that. If some of you have that information, you can email it to me. Then somebody told me the cookies also have an institution. I don't know whether I'm relating to you what our institution is like. If you have a similar one, please let us know, because we should also meet, try and figure out whether we have anything in common that we can pursue with the government of India. Because government of India also is finding, finding it very tough because they're saying it could open up a Pandora's box. If they give it to us, then they will, be as it may, our customary laws is such that the government of India will have to address our treaty. There's no way that they can avoid it. In May 1999, when I first interacted with the Home Ministry, I went and met G.K. Pillai. I don't know if you remember him. He was then the Joint Secretary Home, in charge Northeast. And then he finally retired as a secretary. When I met him, I asked him. So he said, no, this treaty is 1947. You already have a state, you have a district council. This is like, let's not talk about this anymore. In other words. So I told him, the chiefs have sent me to ask you why you're not honoring your part of the commitment. No, we have given you a state. We have given you district council. Same reply. And so finally I said, okay, you do one thing. If you say that this treaty is not, of any good today, please give us a letter. Give us a letter that this treaty is over. So he asked me, how will it help if we give you a letter to say that this treaty is over? And I said, then the chiefs want a letter from you so that they can now decide. If you say this letter is dead, this treaty is dead, we will now decide then where to go. This is one aspect which till today, our treaty is still causing a lot of speed breakers to central acts, and we are still in conflict till today. Thank you very much, and wishing you all the best once again.